Now we get to Lively's opposition to Wayfarer's motion, limine number 15, which sought to preclude evidence concerning the following irrelevant topics, is what it says. And as we went through the motion, there was just like, a multitude of topics. Let's see what Lively has to say. Defendants request that the court exclude evidence on 9 topics without explanation and supported solely by citations. Defendants' request should be denied for 3 independent reasons. First, the motion should be denied as impermissibly vague. Second, each specified category of evidence is plainly relevant. Third, it seeks relief duplicative of that requested in a pending Daubert motion. First, the motion should be denied as impermissibly vague. A district court is well within its discretion to deny a motion in limine that fails to identify the evidence with particularity or to present arguments with specificity. Defendant's motion suffers from both flaws. Defendants simply enumerate in a numbered list the topics of evidence they deem appropriately subject to exclusion. None sufficiently identifies the evidence defendants seek to exclude. For example, defendants seek to categorically exclude videos, podcasts, speeches, and other material, such as full episodes of Baldoni and Heath's Man Enough podcast and Baldoni's books, because it's irrelevant. It's irrelevant to a point. I mean, the counter argument is, well, Lively's going to say, well, hold on a minute. To defend yourself, from the retaliation claim, you're going to try and bring in evidence of my past behavior. And I'm going to have people saying to me, well, hold on, why is it okay for Wayfarer to argue that, they can bring in, past interviews, etc., irrelevant stuff, which is on the surface irrelevant. But Lively can't do the same and bring in, like quotes from Baldoni's, like TED Talks and books, etc., where he's maybe admitted to, doing things or, not always being a particular person. Well, with retaliation, right? So Lively's trying to address, is my reputation caused by Wayfarer, or is it caused because my reputation was shit anyway? And that's where her past interviews and so on and so forth are kind of relevant here. And I think Wayfarer are within their rights to bring that, to prove it. Hold on. Because she's saying, my reputation was great, and then all of a sudden it tanked. And Wayfarer saying, well, no, your reputation actually never was that great. And here's all the evidence to prove that. Whereas Lively is saying, well, look, Baldoni's admitted to doing bad acts, to not always listening to women, so on and so forth. Now, there's a two-pronged thing here for me, right? Is it shouldn't be allowed because it doesn't prove any of Lively's claims, right? It doesn't go to Lively's reasonable belief that she was sexually harassed. She did not read fucking Baldoni's book. She didn't even read Colleen Hoover's book. She did not read the book ahead of time and go, oh, I believed. And she's already got Liz Plank lined up as a witness who was on the podcast. We don't need in the entire episode of the podcast. But then also, if you let her have all this stuff, right, this stuff from years ago, it is literally Baldoni saying, hey, do you know what? I recognize I didn't do so well here. I need to improve on that. And he's got enough self-awareness to say, I need to do better. And along the way, he's trying to encourage other men to do better. So Wayfarer can actually, if this does go to trial and is offered as evidence, and Wayfarer can quite easily rebut it as a bad thing and defend it and say, hey, do you know, so what? He took accountability for where he went wrong. He's been open and honest about where he's gone wrong and said, hey, I need to do better. And then tried to be an example to other men. You've got a problem with that, Lively? I mean, I don't think they'll be allowed to do it, but it would be poetic justice if they could bring in all the clips of Ryan Reynolds, talking about how much of an asshole he is. Like the things he got his daughter to say on Deadpool and Wolverine, how many times she had to say that line against her will. The fact that he admittedly stared at women's breasts, and so on and so forth. Even the lines of Deadpool about how he wants to blow Nicepool's head clean off and so on and so forth. I think that was Deadpool's lines talking about Nicepool. But the fact that, and the fact that he's admitted to setting fire to his school or just being absolutely awful as a kid, and then sort of put into Blake Lively, do you like that kind of man? You have a problem with a man who has self-awareness about his shortcomings. You married someone who admittedly set fire to his own school and was a bully. They won't be able to do that, but it would be lovely if they could get into that. I don't know, if Lively opened the door, they could actually get into that. Okay. So she continues, they did not identify the portions of podcasts, books, or speeches they seek to exclude. Likewise, defendants seek to exclude evidence regarding whether consent was provided for tape-recorded phone calls without specifying the phone calls at issue or the persons who did or did not consent. Okay. So what this is I think a couple of calls or video calls were recorded, not necessarily with consent. Now, when I looked at these at the time, none of them were actually illegal. They were in one-party states. The library is like, well, hold on a minute. I want to bring in evidence that, they recorded people without their consent. Okay, fine. But she is also further back, if we remember, she's got an entire motion limine where she wants to include a recording of Steve Sarrett that Claire Ayub made without his knowledge or consent whilst he was in a two-party state. And that's the hypocrisy of this. Defendants also seek to exclude unspecified comments on various social media posts endorsing Lively's allegations. They identify, because it's unduly prejudicial. It's got nothing to do with. You can't endorse Lively's allegations unless it's someone who actually witnessed it. You can't endorse it. If someone has had a separate experience that's completely unrelated, that Lively was not aware of and did not witness, and they did not witness or were aware of Lively's allegations, and really, one does not prove the other. They identify two examples of such posts, but do not otherwise identify the particular comments or which of Lively's allegations or comments allegedly endorsed. Yes, because you want it to be put in a filing so the media can go nuts with it. Without the detail outlined here, the court has no ability to review the documents and determine whether there are grounds for exclusion. The motion should be denied on this basis. As for the legal basis for exclusion of the 9 topics in the preambulatory paragraph of their motion, defendants state that none are relevant and claim that they will lead only to juror confusion, unfair prejudice, and an unnecessarily long trial. I agree, this is an awful lot of information to try and prove. 1, you had a reasonable basis for believing that you were sexually harassed, even though by the legal standard you were not. And 2, you reasonably believed that they retaliated against you and smeared you because you spoke up about your alleged perceived sexual harassment. All of this is not necessary. And then obviously there's the breach of contract claim, which, I could make disappear with one paragraph. Defendants' unsupported, unexplained assertions cannot dictate the admissibility of key and relevant evidence in this litigation. Second, the motion should be denied because the evidence it seeks to exclude is relevant. The articles, videos, podcasts, speeches, and books featuring statements by Baldoni, Heath, and Sarowitz, for example, are relevant to Lively's claim of retaliation under FIHA. No, they're not. Specifically, they are relevant to show defendants' retaliatory motive, Lively's protected activity, risk Baldoni and Heath, and by extension Wayfarer and the Ends With Us movie, being seen as unsafe and harassing to women, a reality Baldoni and Heath recognised in real time. The protected activity, along with the implications thereof, was an existential threat to the feminist and purpose-driven brand Wayfarer, together with Baldoni, Heath and Sauerers, had carefully crafted. It was wholly inconsistent with the public personas they had developed for Wayfarer and for themselves. So she's just going to quote portions of the book, etc. Anyway. Lively's protected activity was wholly inconsistent with the behaviour of the faith-centric, accountable and thoughtful allies. We're knocking the face now again. And thoughtful allies that Baldoni, Heath and Sauerets purported to be. They had a retaliatory motive to silence and attack Lively. As the person threatening to undermine the personas developed in the articles, speeches, podcast books and videos Lively seeks to introduce. Evidence concerning Wayfarer or Ends With Us movies, policies and procedures for preventing and investigating sexual harassment are also relevant and probative of Lively's claim of retaliation under FIHA. Wayfarer's employee handbook, co-signed by Baldoni and Sauerets as co-chairman, incorporates an equal employment opportunities, anti-discrimination, anti-harassment, and anti-retaliation policy. It also details Wayfarer's process for investigating complaints of wrongdoing, including the requirement to maintain appropriate documentation and tracking throughout the investigatory process. Notwithstanding these policies, Heath relayed to producer Sachs that he did not want Wayfarer to conduct an investigation into concerns about his and Baldoni's behaviour because he didn't want a written record of it anywhere. Now, I'm not sure. I can't remember off the top of my head. Maybe you guys can let me know in the comments. Was Heath asked about that at his deposition? Did he admit that or deny it? Because if he denied it, it is his word against Alex Sachs's. And unless Lively was actually there and heard it herself, or, someone else who can corroborate one way or another, it's, one word against the other. And Lively cannot rely on it this heavily. The law is clear that failure to conduct a rigorous investigation may be compelling evidence of an employer's retaliatory animus or malice. Evidence of Wayfarers and It Ends With Us movies policies are relevant to show that they did not take preventative and investigative steps pursuant to them, which is relevant to Lively's retaliation claim. Defendants conceded such relevance when including Wayfarer's employee handbook. Evidence concerning picketing or respect or lack of respect for picketing during writer's strike is also relevant to Lively's retaliation claim. Once again, because of Wayfarer's own words and actions. Lively would not offer evidence that Baldoni broke and pressured his subordinates to also break the picket lines to show that he is a person of poor character. Instead, the purpose of the evidence is to show the retaliatory motive Wayfarer had in its placement of media stories falsely emphasized with italics, accusing Reynolds of crossing the picket lines for writing during the strike. Right. Okay, please, I'm going to put all the links to all my union videos, right? Please go through them because I went through a huge deep dive with the various rules, regulations, constitution, code of, blah, blah, whatever, code of standards, etc. for all of the various unions here. That's the DGA, that's the PGA, that's the WGA, and it's SAG-AFTRA. And I went through them all. And I explained in forensic detail that Ryan Reynolds had breached WGA rules, right? Not just for the fact that although there's a dispute about the dates, right? The timing suggests that he wrote the rooftop scene around, during, or incredibly close to the writers' strike, okay, which he is a member of. But regardless of whether he did it during the strike or not, is rather irrelevant because he still broke the rules by writing without any authorization, without notifying the WGA, without seeking any fee or any credit. So, no, I am not going to. I'm not tolerating this crap from Lively. I'm really sick of it. They all breached various rules, and there may be a bit of a quibble over that was my very British wordsmith coming back into play. That quibble. There may be a bit of a quibble over whether it was because the writer's strike was like, I can't remember the exact date. It was like the very end of April, the very start of May, and Reynolds was, certainly there was the whole conversation of can I write the rooftop scene was middle to end of May, not May, April, right? That all took place then. So we don't know whether at what point Reynolds was actually physically writing. He may not have been doing it during the strike, but it is so close in time that you can, understand why people believe that he did do it during the strikes. But regardless, he shouldn't have done it at all because he still broke WGA rules doing it. Wayfarer had no idea that Ryan Reynolds was writing that scene. They thought Lively was, because Lively had given them the whole sob story of, I'm a woman and I keep getting held back and told I can't do these things. And if I do them, I can't accept credit for it. Blah, 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 which I don't give a shit. Oh, and by the way, I got dragons. And Lively pleaded to be allowed to do this stuff, and used her gender to get her own way and get that authority from Justin Baldoni to contribute to the writing of the rooftop scene. And then she handed it to her husband to write it. And I'm getting pissed off with this. There is no false accusation here. And who gives a shit whether Ryan Reynolds crossed picket lines or not, right? Lively shouldn't have went on strike when she shouldn't have even gone on strike because SAG-AFTRA has a no strike rule. In fact, all the unions do, where just because, like if you're in this case, if you're a member of SAG-AFTRA and as did happen, the WGA goes on strike, you do not then suddenly down tools in your acting career and join the picket lines for WGA members in some kind of show of solidarity. There is literally a clause that says do not do that. And she did it anyway. And then criticised Baldoni. Oh, I knew something was going to get to me. I knew it, and there it is. So here we are. Again, we are now making the retaliation about Ryan Reynolds, who once again has no reasonable basis to believe that he was sexually harassed, did not complain about sexual harassment, and even if he did, he has no basis to believe that, he's been retaliated against for it. So why is his reputation being brought into this? I have no idea, because there is nothing actionable about that. And Ryan Reynolds falsely accused Justin Baldoni of being a sexual predator. Not only did the defendant attack Lively's husband with no basis, whatever, and then she has the cheek to put in brackets, he did not serve as a writer on the film and violated no guild rules at any point in time. Lady, are you fucking kidding me? She said he wrote the rooftop scene. The gaslighting that is going on is just insane. I'm going to read that again because I've lost my trail of thought now. My feathers are ruffled. Not only did defendants attack Lively's husband with no basis, he did not serve as a writer on the film and violated no guild rules at any point in time, which is not true. And again, my videos prove that's not true. They deliberately attacked him, knowing full well that Baldoni had not only regularly crossed picket lines, again, there's no evidence of that, but pressured others on the cast and crew to do the same. Baldoni admitted the same, stating, "I think every time I was on set during the writer's strike, I was crossing the picket line." Yeah, no, I think Baldoni's a bit confused about the rules. Because, there was a strike and then it was called off like a day or two later, and they were actually given the go-ahead, but they downed tools whilst waiting for the green light to continue, which they did get. Despite this, he's claimed that the production was responsible for asking people to cross the lines. Thus, for example, conversations between Lively and Jenny Slate regarding how uncomfortable Baldoni made Slate by finding ways to sneak into work during the writer's strike are directly relevant to defendants' later retaliation on the very same subject. That was a PR hit piece. The remaining evidence defendants seek to exclude is likewise relevant to Lively's retaliation claim under FIHA. Baldoni and Heath's receipt of consent for certain tape-recorded phone calls, including one with Slate and Lively, is directly relevant to whether Lively's belief of harassment or other wrongdoing in violation of FIHA was objectively reasonable. You were recorded, that's not harassment. It was nothing to do with your gender or protected characteristics. Shut up, woman. Evidence and argument concerning Lively's damages claims are relevant to show and calculate the type of harm Lively suffered by defendants' retaliatory campaign, and the social media comments reflected are relevant to rebut a defense argument that Lively had a poor public image before August 2024. If she thinks that she didn't have a poor public image before August 2024, then she's been going through life with her fingers in her ears going la 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 la. Because she was, I've done another video today actually on this where a Disney executive, no less, Hollywood Insider, actually came out and referred to Blake Lively as difficult, toxic, and one of those people who always thinks that she knows better. Okay. As for the final topic of evidence defendants seek to exclude, defendants also contend that Lively plans to offer 2 exhibits to highlight comments on various social media posts endorsing Lively's allegations. That is incorrect. An Instagram video posted by Baldoni is an excerpt of a September 26, 2023 episode of the Man Enough podcast, where Baldoni references just 3 months after the filming of Phase 1 concluded, saying things he could not have said while filming It Ends With Us movie. They put movie at the end of that. It's not supposed to be. Things he should not have said while filming It Ends With Us, compelling him to reread his own book. Yeah, because he was being bitch slapped down every time he opened his mouth. He was told, no, you can't say that. Just made the guy question himself. That's all. That's all that proves. Baldoni's admission is direct evidence that he knew in real time, i.e. when and after Lively's concerns about his conduct, Lively raised concerns about his conduct, that he had crossed the line on the film set. The typos in here are stupid, but also no, it doesn't prove that Lively was right. It just proves that Lively moaned enough and made him feel bad enough that, he revisited his own words to remind himself, okay, I need to do better. Objectively, the majority of the public think that Lively's complaints and niggles and quibbles are just ridiculous and snowflakey. You just made this very sensitive man question himself. There's not evidence of anything. It's not, and it's certainly not evidence that Lively was reasonable in any way, shape, or form. I'm yet to see any evidence of that. PTX 409A is separately relevant to Baldoni's engagement in floral-centered marketing of the film, a promotional approach he weaponized against Lively when contrasting his later domestic violence-focused promotion of the film against Lively's floral and fashion-focused promotion. Also, it was Lively's floral and fashion-focused promotion. Got it. Yeah, but he wanted to talk about domestic violence, and Sony pushed back. I mean, I'm sorry, I'm just not buying it that Baldoni wanted to make this all about florals and flowers and shit like that. He already seen the backlash that Colleen Hoover got for the nail varnish and the colouring books. In fact, he had to help bring in Stephanie Jones to kind of fix Colleen Hoover's image after that. Third, defendants seek to exclude evidence and arguments concerning damages claims as discussed in the Wayfarer parties accompanying Daubert motions. By defendant's admission, this request is duplicative of the arguments raised in defendant's Daubert motion to exclude the testimony of Jeffrey Kinrick, Michael Sipple, and Richard Marks. Defendant's request should be denied on that basis. Wow, this was a really rage-inducing segment of this motion. I cannot believe that she is seriously trying to say Ryan Reynolds was not a writer in the film, had no writing role in the film. Lively, someone told Lively that we all know that, but it feels like Ryan Reynolds and Blake Lively did not know that, because this is what I don't get, right? And it feels like it's gaslighting, because it's her words that everyone heard, and it's her words that everyone relied upon and refers to whenever we talk about Ryan Reynolds writing the rooftop scene. So for her to put so blatantly, like, well, I don't know what you're talking about. He had no role in writing and on the movie, and he broke no guild rules ever. Okay, well, let's write a letter to the WGA and let's see what they say. They may agree, but I pointed out every single fucking rule that he broke. So, yeah, I don't agree with that. Okay. Yeah. If I was Wayfarer, although it's irrelevant, and Ryan Reynolds is irrelevant because he's not in this, and it's not about retaliation or smearing his name. No one gives a shit. But, if I was Wayfarer to rebut this, I would bring in someone from the WGA, or I would, enter into evidence all the rules of the WGA, because he broke a lot of them. Again, I've done, an entire video on this. Okay. Next video is Lively's opposition to defendant's motion in limine number 16, which is to preclude evidence and argument of reputational harm damages.